from the office of Alufe.
Okay, so this is a judgment of the court.
Very well, sir.
The claimant filed a complaint pursuant to Order 3, Rule 2 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 on the 7th day of May 2018, whereas the claimant claims against the defendant the following reliefs. A declaration that the claimant is a retiree of the defendant by reason of the fact that the claimant meritoriously served in the establishment of the defendant from 2nd October 1986 when the claimant was employed in the services of the defendant and retired from the service of the defendant on the 24th day of April 1997, having regard to the claimant's letter dated 24th day of April 1997, entitled Retirement Notice, by which the claimant applied to the defendant to retire from the service of the defendant, which was done in accordance with the civil or public service rules and other enabling laws in that behalf. The declaration that the claimant, who is a retiree of the defendant by reason of the fact that the claimant meritoriously retired from the service of the defendant on 24th April 1997, is entitled to all her retirement benefits appertaining to the claimant in her capacity as a retiree of the defendant, as provided for by the law under the civil service or public service rules and other enabling laws in that behalf. An order of mandatory injunction compelling the defendant to compute, assess, and pay with immediate effect all the claimant's retirement benefits from the 24th day of April 1997, when the claimant retired from the service of the defendant to date. 21% monthly interest on the said sum standing to the credit of the claimant as a retirement benefit from 24th day of April 1997, when the claimant retired from the service of the defendant to date, until the date judgment is delivered in this case. 10% monthly interest on the said sum standing to the credit of the claimant as a retirement benefit from the date judgment is delivered until the judgment debt and other incidental costs are fully paid by the defendant as provided for, either by the rules of this honorable court or the judgment of this court. 50 million naira only, being general damages for the cost of litigation, emotional, psychological, official, social, and incidental humiliation or inconveniences suffered by the claimant in the hands of the defendant as a result of disappointing and frustrating acts of the defendant. The claimant predicated her claims on the statement of facts filed on the 7th day of May 2018 and witness statement on oath filed on the 9th day of October 2019. The defendant, upon being served with the complaint, filed a statement of defense on the 7th day of June 2018 and a witness deposition on oath filed on the 5th day of May 2022. The defendant counterclaims and seek the following reliefs against the claimant cross-defendant as follows. 1. A declaration that the purported retirement of the claimant stroke defendant amounts to termination of her employment with the defendant counterclaimant. A declaration that the claimant defendant refusal to sign the bond and meet with the conditions of bond as provided in clause 115 of chapter 2 of staff development program of the institute is a flagrant breach of the condition of service to the defendant counterclaimant. An order compelling the defendant, the claimant defendant to pay the defendant counterclaimant the sum of 445,457 naira 50 kobo only, being salaries collected by the claimant/defendant from the defendant counterclaimant from the period 1st day of October 1994 to 17/9/1996, and any other suitable relief. At the preliminary trial on the 17th day of February 2022, wherein the claimant called a sole witness, the claimant who testified for herself herein refers to as CW1, identified her deposition on oath made on
Nigeria. I've lost connection. Well, I'm sure he will be back. Maybe they are not even aware that we have lost connection. I'm sure they are not even aware.
It says it's being live streamed on YouTube. How do we get to YouTube and see it?
Yes, can you hear me?
Yes, my lord, I can hear you. Glitches.
At the preliminary trial on the 17th
Yes, we
day of
can hear
February
you.
2022, where the claimant called his sole witness, the claimant who testified for herself, hearing refers to a CW1
Sorry, we're having serious issues, please. We're having technical issues. I hope you can hear me now.
Yes, my lord. I can hear you now, my lord.
Can you hear me?
Yes, sir.
Okay.
I can hear you, sir.
I can hear you very well too, sir.
At the plenary trial on the 17th day of February 2022, where the claimant called a sole witness, the claimant who testified for herself hearing refers to as CW1, identified that the position made on oath on the 9th day of October 2019 and adopted same as her evidence in support of her case. CW1 thereafter tendered documentary evidence and same were admitted in evidence and marked as exhibit CW001 to CW016 respectively. On the 23rd day of October 2023, the defendant opened its defense. Mrs. Andeline Ekweze, hearing refers to as DW1, testified for the defendant. DW1 identified a statement on oath filed on the 5th day of May 2022 and adopted same as evidence in support of the defense of the defendant. DW1 thereafter tendered documentary evidence and the same were admitted in evidence and marked as exhibit DW001 to DW005. After the close of the hearing of this suit on the 10th day of June 2024, the matter came up for adoption of final written addresses filed by counsel. Counsel for the defendant, Ebimo Bwere Anuata, identified its final written address filed on the 4th day of April 2024 and adopted same as a legal argument in aid of the case of the defendant, while urging this court to dismiss the claim of the claimant and to grant the counterclaim reliefs. Counsel for the claimant, Aki Oiboro, identified the written address file on the 31st day of May 2024 and adopted same as his argument in support of the case of the claim of the claimant and urged the court to grant the relief sought by the case of the claimant in brief. The conspectus of the claim of the claimant is that the claimant was a staff of the defendant as a lecturer in the Learning Institute of the defendant. The claimant is now a retiree of the defendant. The claimant having meritoriously served the defendant for a period of 11 years or thereabout. The claimant stated that on the 2nd day of October 1986 or thereabout, she was employed by the defendant as a lecturer in the defendant's institute. That in 1990 or thereabout, that was after working with the defendant for about 4 years, the claimant went for further studies to acquire her MSc at the University of Port Harcourt with the permission of the defendant. The claimant completed the master's degree program in the University of Port Harcourt and resumed duty with the defendant in December 1990. During the master's degree program, the defendant paid the claimant her salaries while the claimant sponsored all the expenses of the degree, even though the defendant ought to have sponsored the master's degree program. In 1992 or thereabout, the claimant sought permission for a PhD at Queen Mary and Westfield College, London. When securing the admission, the claimant approached the defendant for sponsorship. The defendant then informed the claimant through the defendant's principal, Mr. Onipede, that the defendant was not in a position to afford such amount of money. The defendant then advised the claimant to seek sponsorship elsewhere, that the defendant will only have to pay 15% of the total cost of the PhD degree program and the claimant's salary in Nigeria. Following the defendant's advice, the claimant then approached several companies for the sponsorship of the said PhD program. Eventually, Chevron UK Limited, a multinational oil company, there to Chevron UK Limited requesting for the sponsorship. The letter was written by the defendant, and Chevron UK Limited agreed to sponsor the first year of the PhD program because registration for course had to be for an MP 1 year initially, and the claimant could only transfer to PhD on successfully passing an examination. The claimant further stated that on the 11th day of August 1993, the claimant started a PhD course in the United Kingdom. However, the agreed 15% of the total cost of the PhD program, degree program, which the defendant promised to pay, was never paid by the defendant. Upon the completion of the first year of the PhD program, the claimant wrote a letter dated 24th day of April 1994 to the defendant, requesting for an extension of support for the PhD program for both the defendant and Chevron UK Limited. Upon the receipt of the said letter, the defendant did not reply to the claimant's request. Chevron UK Limited granted the claimant's request for an extension of support for the PhD program. Surprisingly, the defendant stopped paying the claimant salaries in Nigeria. 2 months later, the defendant, through her registrar, Mr. Apobi, telephoned the claimant in the United Kingdom, find out of the claimant was lucky with her research sponsorship and further requested for a proof to that effect. The claimant then sent a copy of the letter dated 16th August 1994, by which Chevron UK Limited approved the extension of her support for the claimant's PhD degree program to a defendant. Thereafter, the payment of the claimant's salary was resumed without any correspondence. On the 13th day of January 1996, the claimant got married in London, and on the 11th day of May 1996, the claimant gave birth to her first son. The claimant's condition as a nursing mother delayed her research by a few months. However, the claimant communicated with the defendant at every stage of the PhD degree program about the progress of work. The claimant eventually defended her thesis in March 1997. By a letter dated 15th day of March 1997, titled Completion of Course and addressed to the defendant through her registrar, the claimant asked for time off to enable the claimant participate in the celebration of the graduation ceremony for the PhD students scheduled for July 1997. Further stated that by a letter dated April 1997 and titled Resumption of Duty in the Institute, the defendant, who is already aware of the forthcoming graduation ceremony to be attended by the claimant, asked the claimant to resume duty immediately, failing which the claimant will be regarded as an absconder. The claimant maintains that the said letter dated April 1997, by which the defendant asked the claimant to report for work immediately, was the first official communication which the claimant received from the defendant since the claimant started a PhD program on the 11th day of August 1993. Following the receipt of the said letter, dated April 1997, the claimant returned to Nigeria and resumed duty on the 21st day of April 1997 and filled the resumption certificate dated 21st day of April 1997, which indicated that the claimant had actually resumed duty with the defendant. Upon the claimant resumptions of work, the defendant posted the claimant to the Department of Industrial Safety and Environmental Engineering. The claimant went to the bank to check her account. The claimant was surprised to discover that the claimant's salary had been stopped since 17th day of September 1996, that is 6 months before the end of the claimant's PhD course. The claimant then requested the defendant to pay her the claimant's salaries. On requesting for the payment of her salaries, the defendant then ordered the claimant to sign a bond in retrospect, vowing to work with the defendant for a minimum of 2 years for the payment of the claimant's salaries will be restored. The claimant refused to sign the said bond in retrospect as the claimant believed that it is illegal. The claimant then decided to retire from the service of the defendant on the 24th day of April 1997. The claimant was then requested by the defendant through our registrar, Mr. Kobi, to pay 1 month salary in lieu of notice, which the claimant paid accordingly. That a month after the claimant had paid 1 month's salary in lieu of notice, rather than contacting the claimant as usual, the defendant contacted the claimant's mother, who was also a staff of the defendant, and told the claimant's mother to inform the claimant to pay 3 months' salary in lieu of notice, as the defendant was not happy with the 1 month salary in lieu of notice, which the claimant had earlier paid. The claimant then requested her mother to get the correct assessment of the account amount in lieu of notice to enable her to pay the 3 months salary in lieu of notice to the defendant. The defendant then assessed the 3 months salary in lieu of notice in writing to be 107,124 kobo, which was given to the claimant to be paid. On 29th of the assessed 3 months salary in lieu of 94 kobo, the claimant immediately paid the said sum of 107,124 kobo, which represented the 3 months salary in lieu of notice to the defendant. The defendant then issued the claimant with a receipt in acknowledgement of the receipt of the 3 months notice in lieu of notice. In spite of the fact that the defendant has received the initial 1 month salary in lieu of notice and subsequent 3 months salary in lieu of notice from the claimant, the defendant failed, refused, or neglected to issue the claimant with a letter of confirmation of the claimant's retirement. Instead, the defendant wrote a letter dated 25th day of September 1997 to the claimant's mother, instructing the claimant's mother to vacate the claimant's official residence. By the said letter, the defendant acknowledged and confirmed the fact that the claimant's retirement, surprisingly, despite the defendant's and continuously withheld the claimant's retirement benefits effect, that in August 1997, or thereabout, the defendant wrote yet another letter which was sent to the claimant's mother's address. By the said letter, the defendant requested the claimant to pay a whooping sum of 552,458,094 kobo only, being a refund of salaries paid to the claimant, while the claimant in addition, by the said letter, the defendant also requested the claimant refused to pay the said whooping sum of 4 kobo only, as the claimant was a total of provided for under the Civil Service of Public 1998, which was about 15 months after the via the letter dated 19th day of August 1998 from the defendant for not resuming duty or paying the required whooping sum of 552,458 naira 94 kobo only. The defendant then gave the claimant 96 working hours to respond. This was the second and final correspondence the claimant received from the defendant in the United Kingdom, that the defendant approached the claimant through her various principals to resolve the matter with the claimant, but to no avail. Eventually, on 22nd day of October 2014, the claimant met one of the principals of the defendant called Mr. Alkali, who advised the claimant to write a reminder. The claimant had two separate reminders, dated 11th of November 2014, and 1st of March 2015, respectively, reminding the defendant of the claimant's retirement from the defendant's service till date. On the 14th day of October 2015, who is the defendant's principal, I reminded him of the need for the defendant to treat the claimant's retirement issues with a view to paying the claimant her retirement benefits. The said Mr. Orikele informed the claimant that the matter has been transferred to Board of Trustees for months now, and the matter is still unresolved, as the matters of the board are in disagreement. The defense and the counterclaim of the defendant. Let me briefly state the case of the defendant in brief. The defense and the counterclaim of the defendant is that the claimant was employed on the 2nd day of October 1986, and the terms regulating her employment, including retirement from service of the defendant, are contained in the letter of offer of employment dated 24th day of September 1986, and the institute condition of service for that period, that in conjunction with Chevron UK Limited, the defendant did not sponsor the claimant to the UK for her studies in the first instance. As a matter of fact, the claimant was expected to immediately return to her duties upon completion of the said program. The claimant never consented or approved any extension or support period for the claimant's further pursue a PhD program. With said program, the claimant went ahead to do outside the agreed period. The claimant was allowed to stay for the initial program. The claimant flagrantly failed and was still paying the claimant's salaries, even though the claimant was an institution established by the law and the master of the defendant's procedure to grant permission by telephone call without any formal correspondence to any of our employees. The claimant did not communicate with the defendant in any form whatsoever in respect of the claimant's purportedly being nothing more. After claimant's long absence from duty without any form of valid permission from the defendant caused a letter to be written to the claimant paid the claimant for the period the claimant was not given permission to be absent from opportunity to further her studies, while the employer that the claimant will work with the defendant for a minimum period of 2 years. Because the claimant did not want to adhere to the conditions of service, having benefited from same, the claimant purportedly applied to the defendant to retire from the service of the defendant. The claimant does not have the right, after the offer and acceptance of the award, and to do the contrary without breaching the setup. That the claimant having failed to return to serve the defendant after the completion of her initial course, the purported notice of retirement of the claimant is in clear and flagrant breach of our obligation under condition of service. By virtue of the terms of the employment as contained in the letter of offer of employment dated 24th September 1986, the claimant retirement age was pegged as 55 years. The claimant, however, breached the terms of the employment as at when she purportedly retired to the defendant with the view of never returning to resume, while she honestly wants to still benefit from a purported retirement that never existed. The defendant further advised that by virtue of the set terms of employment, the claimant ought to do, having absconded her duties without consent of the defendant, was for the claimant to indicate her desire to terminate her appointment with the defendant and not retirement, as the claimant has clearly and overtly breached the terms of employment. The upon receipt of the claimant's purported notice of retirement, the defendant, through a letter, requested the claimant to refund salaries and allowances she received while she was away from her duties, which says salaries and allowances were paid to the claimant in the face of the claimant's continuous breach of the staff development policy, and also, in addition, 3 months' salary in lieu of her purported notice of retirement of her employment with the defendant. The claimant did not respond to the said letter requesting her to refund the salaries paid to her while she was away from her duties. Neither did she pay the 3 months' salary in lieu of her purported notice of retirement as requested. As a result of claimant's continued absence from duty without authorization, claimant was queried on the 19th day of August 1998 and was informed that her notice of retirement was unacceptable to the institute. The said query was never answered, nor replied by the claimant. And at no time did the defendant approach the claimant through any of her principal to resolve any issue with the claimant. Neither did the defendant receive any letter from the claimant in that regard. Further stated that what was sent to the Board of Trustees of the defendant was the issue of pension, which the claimant was not entitled to. Counsel for the claimant nominated 2 issues for the determination of this suit, to wit, whether the claimant has been able to establish a case on the preponderance of evidence or balance of probability as required by the law. And secondly, whether the claimant is entitled to relief thought in this case. Counsel for the defendant nominated 3 issues for the determination of this suit. That is, A1, whether there existed an employee and employer relationship wherein the same contractual relationship breached by the claimant. And secondly, whether the claimant has been able to prove her case satisfactorily in law to warrant the grant of the reliefs adumbrated in their statement of claim. And thirdly, whether the defendant has proved her counterclaim on the preponderance of evidence or balance of probability. Having critically digested the facts presented by parties before this and legal submission of counsel for both sides, I am of the view that issue 2 nominated by the defendant is impregnated with issue 1 nominated by the defendant and 2 issues nominated by the claimant. Thus, for this reason, the court will adopt issue 2 and 3 nominated by the defendant to determine the legal issues arising from this suit. For the avoidance of doubt, the issues for determination of this suit are as follows. 1, whether the claimant has been able to prove her case satisfactorily to warrant the grant of the reliefs as claimed. And secondly, whether the defendant has proved her counterclaim on the preponderance of evidence or balance of probability. So I will skip your legal submissions and then I'll go to the decision part of this judgment. You know what you have submitted, so I'll skip your submissions and I will go to the decision of
As the court pleases. As the court pleases.
Can you hear? Okay.
Yeah, very well, sir. As the court pleases, sir.
Court decision. I have carefully analyzed the evidence adduced by both parties, including all the processes filed and submissions made on issue 1, which borders on the claim of the claimant. First thing first, it is important to state from the outset that gleaning from Gleaning from Exhibit CW001 and DW001, the claimant was employed by the defendant on the 24th day of September 1986. Thus, there was employment relationship between the claimant and the defendant before their relationship turned sour. The issue is not in dispute, and any issue that is not in dispute need no further. See the cases of Owan Overseas Agency Nigeria Limited against Browen Energy Trading Company Limited. It's a 2022 case. And then the case of NAS Limited against UBA PLC, or Folete against the state, and Gaji against Pi, or citation provided. It is also important to note that contract of employment is classified in the Nigerian as purely master and servant, one in which is called Durante Beno Placido, and the legal palace is regarded as the one clock with the MC.
The thing is continuing. This is the most important part. Yeah, the thing is doing it. Hello, can you call hear me? We've completely lost contact. We are not with the court anymore. If the court registry can hear me.
We can't hear the court any longer.
Oh, well. This is the most aspect of the judgment. It's already.
Oh, my lord is muted. Oh, yeah.
Can you hear me?
Can you hear
Yes,
me?
we can hear you now.
Yeah, it's not.
Can you hear
It's
me?
not that I can hear you, my lord.
We can hear you now.
Can you hear me?
Yes, sir.
I
We
can
hear you now, sir.
but I didn't hear you for
The other party, can you hear me?
I can hear you now.
Defendants, can you hear me? Counsel for the defendant, can you hear me?
I can hear you.
For the claimant, we can hear you, my lord.
The defendant, can you hear me? They said they cannot hear me.
We can hear you for the claimant.
Yes,
I
I'm
can
waiting.
hear you.
I'm waiting for the defendant to respond. Defendant, can you hear me?
Defendant, can you hear me? Counsel for the defendant, can you hear me? Defendant, you cannot hear me. No. Yes.
Are they even
Can you
here?
hear me? I want to hear from the defendant if they, because they complain that they cannot hear me. Okay, I'll proceed then. The claimant pleaded in paragraph 5 and 6 of statement of fact and laid evidence to support the fact that in 1992 or thereabout, the claimant sought admission for a PhD at Queen Mary and Westfield College, London, and securing the admission, the claimant approached the defendant for sponsorship. The defendant then informed the claimant through the defendant's principal, Mustawani PD, that the defendant was not in the position to afford such an amount of requesting sponsorship. The letter was written by the defendant. And Chevron UK Limited agreed to sponsor the first year of the PhD program because registration for the course has to be for an MPhil, 1 year initially, and the claimant could only transfer to PhD on successfully passing an examination. The defendant responding to the claimant pleaded in paragraphs 9 and 10 of statement of defense and led evidence in support of the fact that in conjunction with Chevron UK Limited, the defendant sponsored the claimant to the UK for her studies in the first instance. The claimant was expected to immediately return to her duties upon completion of the said program. The claimant never consented or approved any extension or support period for the claimant's further pursuit of the PhD program, which said program the claimant went ahead to do outside the agreed period. The claimant was allowed to stay for the initial program. In fact, upon the time the claimant was to resume, claimant flagrantly failed and was neglected to do so. From this piece of evidence, Chevron UK Limited, through the influence of the defendant, sponsored the claimant for 1 year MP program, and the claimant was expected to return to the employment of the defendant upon the completion of the 1 year MP program. Upon the completion of the 1 year MP program, claimant refused to return to her employment. It is for this reason The claimant wrote exhibit CW002 to the defendant, pleading for extension of support to continue the work to the doctoral degree level, and sought the financial support for tuition fees and maintenance for the period between August 1994 to September 30th, 1996. There is no evidence before this court that the defendant granted approval to the claimant to continue her doctoral degree in UK. Gleaning from exhibit CW004, the claimant intended to remain in the UK to participate in the convocation for the award of a doctoral degree slated to be held in July 1997. But the defendant, via the exhibit CW005, requested the claimant to resume duty not later than the 21st day of April 1997. Otherwise, the defendant will regard the claimant as an absconder. The content of exhibit CW007 made the claimant resume duty on the 21st day of April 1997. After the resumption of duty, the claimant stated in paragraph 17 of the statement of fact and laid evidence in support of the fact that the claimant went to the bank to check her account. The claimant was surprised to discover that the claimant's salary had been stopped since 17th day of September 1996. That is 6 months before the end of the claimant's PhD course. The claimant then requested the defendant to pay the claimant's salaries. On request for the payment of her salaries, the defendant then ordered the claimant to sign a bond. In retrospect, going to work with the defendant for a minimum of 2 years before the payment of the claimant's salaries will be restored, and the claimant refused to sign the said bond in retrospect as the claimant believed that it is illegal. The claimant then decided to retire from the service of the defendant on 24th day of April 1997 via exhibit CW007. The defendant stated that the condition of service that allows the claimant to further her studies while in the employ of the defendant also made it mandatory for her to sign a bond that the defendant will work, that the claimant will work with the defendant for a minimum of 2 years. The defendant in paragraph 4.04 of its final written address heavily relied on clause 11.5 of chapter 2 of Start Development Program of the Institute. But the said Start Development Program of the Institute, though was pleaded in paragraph 16 of the Statement of Defense, but was not tendered before this court during the trial. Nevertheless, paragraph 12.2.6 of exhibit DW002 provided that, and I quote, bonding, I quote, staff who are on institute-sponsored programs or on study leave with pay will be expected to sign a bond which will assure the institute of their service at the end of training period. For this purpose, the period of National Youth Service is regarded as part of the bond. Current bond periods will be explained to the potential beneficiaries of the sponsored program. Unquote. The provision of paragraph 12.2.6 of exhibit DW002 will not be well understood in isolation of paragraphs 12.2.1 to 12.2.3 of exhibit DW002, which provides that, I quote, paragraph 12.2.1 provides institute-sponsored training programs, and I quote, the institute has functional and non-functional training programs that are designed to improve specific professional knowledge and occupational skill, as well as the development of managerial skills that cut across functions. In addition, there are institute-sponsored programs which tend to extend over a longer period of time and are designed to improve professional competence and develop new skills. In this type of program, beneficiary continues to receive his formal personal emolument throughout the duration of the course. The institute also bears the cost of training by paying for tuition, boarding, course materials, and allowances. Unquote. Paragraph 12.2.2, which reads personal development training programs, reads, and I quote, these are programs chosen by individual to develop his professional or occupational skills, either in his own spare time or during a leave of absence from work. Such programs will be approved for deserving staff who will be granted study leave without pay to proceed on a course entirely with his own resources. Accordingly, he does not receive any salary or allowance during the period. Study leave without pay is granted to enable an employee retain an unbroken service for pension purposes in case he should to return to the institute on the completion of his studies. However, the pre-employment of such an employee on completion of the course will be at the discretion of the institute, depending on vacancy, position, and the merits of such case. Unquote. On paragraph 12.2.3, which reads study leave with pay, reads, and I quote, The institute may grant study leave with pay to deserving staff. Applicant must be confirmed staff who must have spent not less than 3 years of good service to the institute. If granted, salary and allowances of officers shall continue to be paid while attending the course. The institute shall not be responsible for the officer's course fees or any other study leave with pay, which is 5 years, and reabsorption of the staff after the course is automatic. Uncut. It is axiomatic to know that the sponsorship for 1-year MPhil program or doctoral degree comes under paragraph 12.2.3 of Exhibit DW001. That is, the defendant granted the claimant study leave with pay. As pleaded by the claimant, it is the defendant which facilitated the financing of the training of the claimant abroad. The defendant did not only facilitate the financing of the training of the claimant, but also granted the claimant study leave with pay. There is no evidence before this court that the claimant financed her study abroad by herself, but with the goodwill of the defendant. Thus, the bond the defendant requested the claimant to sign upon her resumption to the duty is valid and legally enforceable, regardless of the time the bond was brought to the claimant to execute, because the bonding is part and parcel of the terms and conditions of service of the claimant with the defendant. The defendant is the goose that lays the golden egg for the claimant, which made the claimant have the opportunity to get sponsorship from Chevron UK Limited. Chevron UK Limited, through Exhibit CW003, sponsored the training of the claimant abroad with the belief that upon completion of her doctoral degree, the claimant will return to the employment of the defendant and be an asset not only to the defendant, but also to the Nigerian oil industry. Thus, the defendant is right to have asked the claimant to execute a bond to serve with the defendant for 2 years upon her resumption to duty, pursuant to paragraph 12.2.6 of Exhibit DW002. Notwithstanding the fact that the claimant was asked to execute a bond after the completion of training, because bonding is part of the condition of service of the claimant of the defendant, which incorporated in the letter of appointment of the claimant, and I so hold. Furthermore, it is also in evidence before this court that the claimant refused to sign the bond and retired from the employment of the defendant through Exhibit CW007. By virtue of paragraph 11 of Exhibit CW001 or DW001, the retirement age of the claimant was pegged as 55 years, and the claimant in her testimony under cross-examination was 34 years old at the time the claimant retired from the employment of the defendant. Flowing from the foregoing, I do not think that the claimant could validly retire from the employment of the defendant having not reached a retirement age. However, a further reading of Exhibit DW002, particularly paragraph 15.4.2, states that any employee who wishes to retire after spending 10 years of service or more with the defendant must give at least 3 months notice of his intention to retire. The claimant was employed on the 2nd day of October 1986 and retired from the service of the defendant on the 24th day of April 1997 after spending over 10 years in the employment of the claimant. Employment of the defendant. After spending over 10 years in the employment of the defendant, given paragraph 15.42 of the exhibit DW002, I have no reason to render exhibit CW007 invalid. Lest I forget, paragraph 15.4.2 of DW002 required the claimant to give 3 months notice of her intention to retire from the employment of the defendant without an option of payment in lieu of notice. But from the evidence before this court, the defendant requested the claimant to pay the 3 months' salaries in lieu of 3 months' notice. The defendant did the assessment of the amount of the 3 months' salaries, and the claimant was expected to pay, bear the exhibit CW008, and the claimant paid the sum of 107,124 kobo, which represented the 3 months' salary in lieu of notice to a defendant. Thus, the payment of the 3 months notice in lieu of notice has cured the seeming premature cessation of the employment contract of the claimant with the defendant. On the issue of pension and gratuity of the claimant, paragraph 15.3 of the exhibit DW002 provides that gratuity and pension are applicable after attainment of 5 and 10 years of service respectively. Any employee who has served the institute for 10 years or more may retire from the service of the institute, in which case he shall have the payment of his gratuity made upon retirement, but his pension becomes payable upon his attainment of 45 years of age. I have no hesitation in holding that the claimant is entitled to a retirement benefit since the claimant was employed on the 2nd day of October 1986 and retired from the service of the defendant on 24th day of April 1997 after spending 10 years in the employment of the claimant. Thus, the claimant is entitled to a gratuity and pension, and the defendant is under obligation to provide the claimant necessary document to process the retirement benefit, and I so hold.
As the court pleases.
The claimant is entitled to reliefs 1, 2, and 3 as endorsed in the statement of facts. Relief 4, 5, and 6 are refused. Firstly, the court cannot grant a prejudgment interest unless if the parties agree to it in the agreement. Prejudgment interest is awarded where there is an agreement for payment of interest or under mercantile custom or under a principle of equity, such as breach of fiduciary duty. In such cases, a claim for prejudgment interest must be pleaded out. Merely stating a claim for prejudgment interest without proof of same is not valid. See the case of UBA PLC against Orunaba. This suit does not come under any of the situations where interest is as of right. Furthermore, the claimant did not plead facts or present evidence entitled her to prejudgment interest. In view of that, relief 4 is hereby refused, and I so hold. On the issue of prejudgment interest, the claim of the claimant succeeds, but there is no monetary claim in the main claim of the claim. For there to be post-judgment interest, there must first be a monetary judgment on which the order for interest will be made until the judgment sum is liquidated. See the case of Africa Prudential Registrars PLC against Macaulay. In the instant case, there was no monetary judgment on which an order for post-judgment can be attached. In these circumstances, relief 5 is hereby refused, and I so hold. Lastly, of general damages is not automatic upon the successful proof of the claim of the claimant. Awarding damages against the defendant will amount to rewarding the claimant for her action to the defendant, which facilitated her training in the UK, with the expectation that the claimant will give back to the defendant the knowledge and qualification the claimant acquired through the goodwill of the defendant by serving the defendant for 2 years. Therefore, I refuse to exercise my discretion in favor of the claimant, and relief 6 is refused accordingly. For the avoidance of doubt, it is hereby ordered as follows. A declaration that the claimant is a retiree of the defendant by reason of the fact that the claimant meritoriously served in the establishment of the defendant from 2nd October 1986 when the claimant was employed in the service of the defendant and retired from the service of the defendant on the 24th day of April 1997, having regard to the claimant's letter dated 24th April 1997, titled Retirement Notice, by which the claimant applied to the defendant to retire from the service of the defendant, which was done in accordance with the Civil Service, Public Service Rules, and other enabling laws in that behalf. And secondly, I declare that the claimant who is a retiree of the defendant by reason of the fact that the claimant meritoriously retired from the service of the defendant on 24th April 1997 is entitled to all our retirement benefits appertaining to the claimant in her capacity as a retiree of the defendant as provided for by law under the Public or Civil Service Rules and other enabling laws in that behalf. And I order a mandatory injunction compelling the defendant to compute, assess, and pay with immediate effect all the claimant's retirement benefit from 24th day of April 1997, when the claimant retired from the service of the date, and I so hope. Now, the counterclaim. I have exhaustively spoken on the issue of signing a bond. Failure of the claimant defendant to sign the bond served the defendant for 2 years after the completion of her PhD, which was facilitated by the defendant, amounts to a breach of condition of service of the defendant. But despite the flagrant breach of paragraph 12.26 of Exhibit DW00C, paragraph 15.42 of Exhibit DW002 allowed the claimant to retire from the service of the defendant after 10 years of service with the defendant, even though refusal to sign a bond with the defendant is in breach of paragraph 12.26 of Exhibit DW002. But that will not invalidate the retirement of the claimant from the service of the defendant. Finally, the defendant pleaded in paragraph 23 of the statement of defense and lead evidence in support of the fact that the defendant requested the claimant to refund salaries and allowances the claimant received while the claimant was away from her duties, which says salaries and allowances were paid to the claimant in the face of the claimant's continuous breach of the staff development policy. Exhibit CW011 indicates that the defendant requested the payment of the sum of 445,457.70 kobo, which the claimant received from the defendant during her training in the UK. Paragraph 12.2.6 of XBDW 002 envisages that an employee of the defendant who is granted study leave with pay will sign a bond to serve the defendant at the completion of the training. The claimant, instead of signing the bond to serve the defendant for 2 years after benefiting from not only the grant of study leave with pay, but also the facilitation of the sponsorship of the program of the claimant by the defendant. Given the conduct of the claimant towards the goodwill of the defendant is entitled to demand every dime the claimant received from the defendant during her study period. After all, he who comes to equity must come with a clean hand. The hand of the claimant is not clean and cannot benefit from her wrong. In the case of Nwosu against APP, the Supreme Court held, and I quote, there is also another maximum of equity that speaks to this case. That is, who he comes to equity must come with clean hand, which bars reliefs for a party that is guilty of improper conduct. CPCP PDP against Ozouka, where in ECO, JSC observed, equity acting impersonally will not allow a party to benefit from its own inequity. It insists that whoever comes to equity for justice must do justice and must not come to the temple of justice with dirty hands, unquote. Flowing from the foregoing, the counterclaim of the defendant counterclaimants succeed in part. Relief 1 is refused, while reliefs 2 and 3 are granted accordingly. For the avoidance of doubt, it is hereby granted as follows. I declare that the claimant defendant refusal to sign the bond and meet with the conditions of bond as provided in clause 11.5 of chapter 2 of State Development Program of the Institute is a flagrant breach of conditions of service for the defendant counterclaim. And I made an order compelling the claimant defendant to pay the defendant counterclaimant the sum of 445,457 naira 70 kobo only, being salaries collected by the claimant defendant from the defendant counterclaimant from the period of 1st October 1994 to 17th day of September 1996. All terms of this judgment are to be complied with within 30 days from today without prejudice to the right of appeal by both parties. I decline to award any cost, and judgment is hereby entered accordingly.
As the court pleases. My Lord, we are very grateful for this well-considered judgment. First and foremost, I want to salute my Lord industry. I want to salute my Lord industry in this well-researched judgment. We appreciate my Lord. For it to be on record, AC Irabo or the Amisis appear with me for the claimant in this case.
AC Irabo
or the Amisis for the claimant.
AC
with AC
yes
Irabo hyphen or their Mrs.
or their Mrs. Okay.
Yes, my Lord. For the claimant,
okay.
He appears with Akio Iboro.
Yes, dependent, nobody.
My Lord, I also want to use this. I want to use the opportunity. I want to see this medium to commiserate with my Lord. In the course of before this judgment, I learned that one of my Lord staff passed on in the Yelegua division. The person of Ebisirima, he passed on. I got that message. I want to commiserate my Lord on the death of the staff of the court. Yes, sir.
Defendant, nobody for the defendant, so that let me know. Defendant, nobody. Counsel for the defendant, nobody. Okay. Okay.
I don't walk around that on Island.
All right.
Very well, sir. Meanwhile, ma. Yes, sir. Okay, fine. We managed to pull through. Yes, the judgment in a nutshell is that the court granted our relief to say you are a retiree of PTI. I think that's very fundamental to us. Yes. No. First and foremost, our first relief. Yeah. Yes. Yes. That's very fundamental. That the court heard that you are a retiree of PTI. And he also gave the judgment that PTI should compute your retirement benefit and pay same to you within 30 days. Yes. Yes. The only thing he gave to them, because they have a counter claim, what he gave to them in their counter claim is that you have to pay the sum of a patry sum of 105, or I didn't write that down, but it's a patry sum of 140-something thousand to be paid to them, to pay to PTI, be the amount you receive while you were studying. Yes. So, and that is insignificant to us. That's not much. So the court refused damages. That payment of damages will be like you benefiting from your wrong. The court refused prejudgment interest. But our cardinal relief were granted. Cardinal relief were granted to the extent. Yeah.
It doesn't matter it doesn't matter what I've been asked to pay. It's unimportant.
Yes.
It's unimportant. I'll pay.
It is.
Oh, this is crazy.
What is important to us is that you are a retiree of PTI.
What is most important to me? Mommy said to me, fight this. And I have spent all these years fighting. And I am happy today. I will go, when I'm in tears. I'm going straight to Mommy's grave now to give her the news. I'm going to her grave right now to tell her.
Can you hear me?
I can hear you.
Congratulations.
I'm emotional right now.
Congratulations. Mr. Ake.
Yes, I'm here.
Congratulations.
No, we thank God.
Congratulations to all of us.
Yeah, we thank God.
I can, yes, thank you very much.
Congratulations, man. So we will okay, let's hope that will reach you. Mr. Ake.
Yes, I'm here.
So that's that aspect of he who comes to equity must benefit from come with clean hands. That's 100 and something. Is that one more? The main cross that she retired.
Send me the bill and we will send it to you so that you can pay it. We will send it to you.
Then what we need to do, we need to get that judgment immediately. I will call the registrar now. Let's see if we can get both the soft copy and the hard copy. We need to get it immediately to read it by ourselves. Although we have heard it, but we need to read it and outline all those things. 30 days, we can work within 5 days, 3 days, get that one done. Then, before we now approach them. Mr. Ake, is that not the position?
No, of course, that's it. That's what we should do.
Then we need to harmonize those things.
Please.
I will reach them. You know, the court just
I have to go now. Please. Let me
problem.
Go now.
I will talk to you later. Please. I will talk to you later, doctor.
Okay. Thank you.
We can understand.
So
Christy will talk later.
Okay. Take care then.
It's all right.